Hi, my name is Matt Christensen. I am a managing partner here at Hansen Johnson. My practice focuses on bankruptcy topics and real estate issues, business-related issues. Today we're going to learn about the different types of bankruptcy, what the purposes of each one are, who the players in each one are, and what the debtor's role in each one of them will be. So under the bankruptcy code, there are 6 official types of bankruptcy. You have a Chapter 7, a Chapter 9, Chapter 11, Chapter 12, Chapter 13, and Chapter 15. I don't know why Congress chose to make 12 the only even-numbered one, but that's how things worked out. If you are an individual debtor, you will normally be in either a Chapter 7 or a Chapter 13 case. A Chapter 12 proceedings are for fishermen and farmers, specifically family farmers and family fishermen. You don't see very many fishermen cases here in Idaho, but family farmers you do see fairly often. And those can be either individual or entity cases. But for a normal individual, you're looking at either Chapter 7 or Chapter 13. Chapter 7 is known as a liquidation bankruptcy. So in that proceeding, there is a Chapter 7 trustee that's appointed. That trustee's job is to locate the debtor's assets and recover assets that the debtor may have transferred prior to filing the bankruptcy case, liquidate all those so there's a pile of money, and then distribute that pile of money to creditors in the case that file proofs of claim. The debtors will have exemptions that they can claim. Those exemptions vary by state, but those are available to the debtors to preserve some of their property without it being liquidated. A Chapter 13 case is a reorganization proceeding for individual debtors. You will never have a company file a Chapter 13 case. In Chapter 13, there's also a bankruptcy trustee appointed. That trustee's job is slightly different from a Chapter 7 trustee. In a Chapter 13 case, the debtors are proposing a plan to repay some or all of what the creditors are owed. Again, creditors that file proofs of claim in that bankruptcy case. The Chapter 13 trustee's job is to ensure that the planned payment that the debtors are making is adequate and as large as it should be. In most Chapter 13 cases, they're not 100% payment plans. The debtor is in essence saying, I have some extra money every month that I can pay to creditors, but not enough to pay all of them in full in the short time frame that they want me to. So it allows the debtor to repay some over time while discharging the balance that they don't pay through the plan. As I mentioned, Chapter 12 is for family farmers and fishermen. There's also a Chapter 12 trustee that gets appointed. His or her job is similar to that of a Chapter 13 trustee to ensure that the Chapter 12 plan is a workable plan that pays creditors what it should be paying creditors. A Chapter 9 case is limited to municipalities. So cities, counties, different subdivisions of a city or a county. Chapter 9s you don't see much in Idaho, and generally a Chapter 9 proceeding has to be authorized by the state that the municipality is located within. Chapter 15 are international proceedings. So if there's a bankruptcy case in Canada that they need to recognize and do some things here in the U.S., then you would see a Chapter 15 case opened and proceed under Chapter 15. The last sort of bankruptcy is the Chapter 11 bankruptcy. Chapter 11 is also a reorganization bankruptcy. Sometimes you'll see a liquidation proceeding in a Chapter 11 case, but generally these are cases where a business is trying to restructure and stay open and restructure its debts or repay them in a different manner to creditors that are owed funds. You can see individuals file Chapter 11 cases, and in which case they're trying to do the same thing. Get a plan proposed and confirmed that allows them to repay the debts that they owe to creditors, just under different terms and under longer periods of time generally. There's a lot of requirements to get that plan confirmed in a Chapter 11 case that may not be present in a Chapter 12 case or a Chapter 13 case. But those 12s and 13s have different requirements in their cases that you wouldn't see in a Chapter 11 proceeding either. Under any of those bankruptcy chapters, there's the automatic stay that kicks in the second you file the bankruptcy that will stay further collection efforts by the creditors, no matter what type of case you file, up to a certain point. So if you're not getting a plan confirmed, if the vehicle that the creditor has a security interest in isn't needed for the plan, then that creditor may be able to enforce their claims against the assets that you may hold. They still will need to participate as creditors through the confirmed plan though. So that gives you a slight look at the different types of bankruptcies, the official types. Sometimes you'll hear of others like a Chapter 21 or a Chapter 22. Chapter 21 just means it's the third Chapter 7 case filed by that person. Chapter 22 means it's the second Chapter 11 case filed by that person or company. So it's not that there's an official Chapter 21 or 22, it's just a combination of several bankruptcy cases. So that, like I said, that gives you a short peek at the different types of bankruptcy. We are happy to answer any further questions you may have about those. You can get in touch with us at our website, www.angstman.com. That's ANGSTMAN.com, or call our office, 208-384-8588.